Hi there. So are you, is it Mohammed Idris?
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Mohammed Idris. If you're not him, you're free to go. We'll issue a warrant for him.
I am the trustee of the person.
So, okay, I'm not sure what that means. You're going to have to explain that to me. I mean, I know what a trustee is. You know, when they have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves, and so that's why, you know. And if you're, I'm not sure exactly what that means, and you're going to have to explain that to me.
What I mean,
like
by
I say, if you're, I mean, I'm sorry.
What I'm saying is the trustee of the person is here, and all the beneficiaries are already been named, and it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors
I'm not.
To be the beneficiaries.
Okay, I'm going to stop you there for a second because I'm not claiming that. No, you can't finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that because that's not true. I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No. Why would you think that?
This is where the case goes off the rails immediately. The defendant isn't answering who he is. He's insisting on what he is. Trustee of the person. That phrase alone tells you everything. He believes legal language can overwrite reality. But courts don't work on magic words. They work on facts, identity, and jurisdiction. And the judge sees that instantly.
Would like to clarify whether Mohammed Idris is intending to go pro se or if he will have counsel at trial.
He looks like he was. Okay, so I'm going to speak here for just a minute, and I'm going to kind of tell you where we are with this, and then we'll go from there. So, you know, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's three things at issue here. There's two statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty, albeit have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if you go to it, since they are criminal cases, it's headed to a jury trial, you're entitled to be represented by an attorney. Look like a previous judge.
Listen to how calmly the judge explains this. No yelling, no ego, just facts. These are simple misdemeanors. Nothing dramatic. 90 days maximum. A fine. This could have been straightforward if the defendant would just engage with reality instead of fighting an imaginary system.
Appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am. Like
you're standing on what?
The trustee of the person is here, and the beneficiaries have already been named.
Okay.
It's on a trust and it's private.
Okay.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt.
Because
I'm brought in as a trustor to give out gifts and turn around. And what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
And I'm not here to give out any gifts.
Okay, no one's here for any gifts.
So I object to that. The trustee of the person is here, and all the beneficiaries are already been named.
All right.
And I'm not talking about.
This is the dangerous part. Not anger, repetition. His not listening. His looping. When someone keeps repeating the same phrase after every question, it's not strategy anymore. It's avoidance. And the judge knows you can't resolve a case if one side refuses to acknowledge the process itself.
What does it have to do with thinking?
Yeah, that's a good question. Well, I mean, you're just telling me that, well, I've named the trustee and the beneficiaries are named who haven't been named to me, so I don't know who they are and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't do it?
And so in terms of, you know, at some point on the there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime, and I've told you what those two crimes are. And now, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice, but it'll come back, I promise.
This is the heart of the case. The judge dismantles the entire trustee fantasy in one simple example. If this worked, no one could ever be prosecuted. Crimes don't disappear because you rename yourself. You don't opt out of criminal law by declaring private paperwork.
Or October 15th. You have the right to an attorney, as I said. You also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. The prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent yourself, you would be at a huge disadvantage. It would be to your great advantage to have an attorney appointed, or you can hire an attorney to represent you. But as I said before, you do have the right to represent yourself. And normally you go through some sort of conversation with folks. I've been doing this job for a number of years now. I've had several people represent themselves. Normally there's a conversation I've had with people about asking them that they're aware that if they represent themselves, they'd be at a disadvantage. I tried to engage in that discussion with you. You just kind of reverted back to repeating that you're the trustee of the person and the beneficiaries and the name, so forth. But rather than go through the question and answer portion, I'm just going to tell you that's where we're at. So we're going to set this case. We're going to do two things here today. We're going to set the case for trial. You're going to get notice in the mail of that. You're also going to I'm going to set a status hearing or a pretrial hearing in about 3 weeks. And then somebody else, maybe it'll be me, will probably try and go through all this again.
This moment is almost sad. The judge isn't flexing power, he's warning him. Going pro Sahir isn't bravery. It's self-sabotage. The prosecutor knows the rules. The jury will know the facts. And slogans won't save you.
Explaining that to you as best I could. And I guess I told you I'd let you speak, or hinted that I would let you speak. I'll go ahead and tell you. Do you have any response or any thoughts on this, or would you understand this is going to trial, or go ahead? I've said what I'm going to say. I'll turn things over to you. Any response to any of that?
Again, I object. I'm standing at what I said.
Okay. And what specifically do you object to? Just so I can create a record, so I'll make a ruling on your objection. What are you objecting to?
I'm objecting to everything you're saying. It's a hearsay. It's an assumption, a presumption. It's a tacit agreement. It has nothing to do with the facts. That's why I'm the trustee. It has everything to do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust.
I object to everything. That's not a defense. That's surrender disguised as resistance. Objections need meaning, grounds, purpose. Otherwise, they are just noise.
And in the trust that you have, the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to to give out gifts. And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts that's supposed to reduce the public debt. Am I wrong?
Yes, you are. And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case, because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, "No, Your Honor, we're going to dismiss this thing." And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward, which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? The short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence? Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else, and I have no documents that saying there's not one, and I don't have any document. There is no document saying that there is one. And so again, that's on that single issue.
So you're not coming after my personal trust?
No.
When the judge finally says, "Yes, you're wrong," it's not insulting. It's honest. He's explaining burden of proof, reality, and consequences. This is the system trying and failing to reach someone who refuses to be reached.
To explain that to you, and I'm more than willing to continue. We can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But again, it's unfortunate. It's a failing on my part that I'm not able to break through to you.
Your Honor, if I might for a moment.
In a minute. So I guess we'll set it for status hearing, we'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now. And so you can raise that, but I'm not denying that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule, this case will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish. But for right now, we're not going to go there. And do you understand what the state just said to me and what I turned them down for? Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
This case isn't funny. It's tragic. Because the law isn't punishing beliefs, it's punishing actions. And unless this defendant drops the script and engages with reality, the jury will do it for him. What would you do if you were sitting there, keep repeating, or finally listen?